Hello and welcome to this edition of TaxSnax. I'm Ross Birkbeck, I'm a barrister at Old Square Tax Chambers, and today I'm going to be talking about appeals in the tax tribunals. And by appeals I mean appeals beyond the first tier tribunal. What happens if things go on beyond there. And I think the first perhaps point to make about this is that appeals beyond the first instance, beyond the first tier tribunal in tax, are actually quite common. And I think the reason for that really is that often in tax, what we're talking about is what the law means. So often I have a tax dispute where there is no question about what happened. The question is about how the law deals with what happened. And that's fundamentally a question of what the law means. And that means it's fundamentally more amenable to appeal to the higher courts, because the first thing to know about appeals beyond high courts is that they are first and foremost about questions of law. The first tier's job is to find the facts, and you won't get a second chance at that. You can, it's true, appeal to the higher courts on the basis that the first tier makes a finding of fact that is unreasonable, that no reasonable tribunal could have made, the so-called Edwards and Bairstow jurisdiction for an appeal. But mostly the question is, an appeal is there's been an error of law. And I think there's just so much tax legislation that's been untested in the courts that there is often scope for asking, has the first tier interpreted this legislation or this provision correctly in a meaningful way? And that's exactly what the upper tier is for, and why a surprising number of tax cases do end up there, or even obviously higher to the Court of Appeal or occasionally the Supreme Court as well. So appeals are quite common in tax. A large number of my matters certainly go to the upper tribunal. So I think what I want to look at today is really the procedure for going to the upper tribunal and then on to the Court of Appeal if that's necessary, and some of the key things you should know and things you should look at. And I'll end up with an important comment and caveat about cost risk, I think, that should be borne in mind. So what happens once you've got your judgment from the first tier and you don't like it, or I suppose the other side doesn't like it, and you want to challenge that decision? Well, the first thing is you have 56 days to file notice of appeal. And at first instance, that's, the way to ask for a permission to appeal is simply to write to the first tier tribunal and ask them to give you permission to appeal. It's a very informal process. Remember, in the first tier tribunal and the upper tribunal, we're not subject to the CPR. We're governed by the first tier tribunal's rules, and then the upper tier tribunal's rules, which are simplified rules, are designed to be more easily understood by the non-lawyer. Query how well that works, but there we go. So you can simply write to the FTT after the decision. I'm appealing your decision on these grounds, and you have to set out the grounds of your appeal. But of course, the FTT will know what the whole case is about. It will know what it decided. So that's quite a easy and quick process, really, because you don't need to go through everything, setting everything out in detail. If you get permission, which actually the first tier is quite generous, I think, in terms of saying my decision actually does concern difficult questions of law. The upper tribunal it might benefit if the upper tribunal had a look at them. But you might get permission from the FTT. If you do, and if you do, then you have to notify the upper tribunal that you've got permission and notify the other side of your appeal, etc. And that involves filling out the form and sending that to the upper tribunal. If you don't get permission from the first tier, you apply to the upper tier for permission to be granted by them, and that involves, as I said, the upper tribunal form for permission to appeal, and you have to set that out and set out therein, your grounds for appeal, including the judgment below, etc. And you've got a month after you were refused permission by the first tier tribunal to get that to the upper tribunal. So 56 days to ask the first tier for permission to appeal. If they say no, you've got a further month to ask the upper tier if they will give you permission. Again, I think the upper tier are quite generous on this, largely, as I said, because there is so much important tax law that has been untested, and the upper tribunal's fairly aware of that and fairly happy to weigh in on how the legislation or other rules should be applied in unique circumstances. So fairly good chances, I would say, if you've got a genuine question of law that your case hinges on. If you've got if what you object to in the first decision is not a legal point, it's a factual point, it's much harder to appeal and much harder therefore to get permission. You have to show that that finding is just simply doesn't stack up on the evidence before the first tier tribunal, that it was nonsensical in some way, or perhaps completely unfounded by the evidence before it. The other issue you might be able to appeal on and get permission on is the exercise of a discretion by the FTT. Often the FTT, a case management decision, for example, or something like that. Again, it's important to remember when appealing that it's hard to win appeals and to get permission as well, therefore, on against the exercise of discretion by the first tier tribunal, whether that's a substantive discretion in terms of a tax liability and how it balanced various criteria, or it's a procedural, often more likely a procedural question. The FTT is given quite wide leeway by the higher courts and the law in terms of how it manages those things and how it exercises discretion. So if you've got, as I say, if you've got facts or discretion that you don't like, it's difficult, and you shouldn't set your expectations too high. Questions of law, of course, however, as I said, are much more likely to be allowed up to the upper tribunal. If you don't get permission from the upper tribunal based on your application, you have the right to an oral hearing. So that's an opportunity for you to go in front of an upper tribunal judge and explain to them your grounds and why you should be allowed to appeal on those grounds. Sometimes that might result actually in the upper tribunal rewriting your grounds of appeal for you. So they might say, well, the ground as you put it is arguable, but I do see on further consideration that you've got a point. I'll allow you to appeal on this ground. And they might clarify your ground into a question of law if you didn't do that properly in the first place. So that does happen. You get refused on the papers, go to court, and you convince the judge that actually you've got a serious point that needs hearing. If you don't get permission from the upper tribunal after that, that's the end of the matter. You can't go to the Court of Appeal or otherwise get around that. That's the end of the matter. So there is a very small jurisdiction to judicially review the upper tribunal for finding permission if there was essentially some severe procedural irregularity, but the law was really tightened on that last year, and I think it's very unlikely to be an option in any case. So that might be the end of the matter. It's also worth remembering that even if you get permission, you don't have an automatic right to suspend payment of any tax that the first tier tribunal says you've got to pay. So you might, even though you're appealing and have got permission to appeal because there's an arguable error in the first decision, you might still have to stump up the money that you've been ordered to pay. And there's no equivalent to Section 55 of the TMA that exists for the first tier proceedings, where there's a statutory test for whether or not you have to pay that up front. The default position is unless the revenue say will accept postponement of the tax, you have to pay it after the first tier judgment. So that could be harsh. The good news is that the revenue normally do allow postponement. In fact, I have known them to refuse postponement on one or two occasions, but that's only where the case on appeal was very weak, and they fought very hard there as well. I think, if I remember rightly, won on that. So, but normally, if you've got a decent case, they're prepared to postpone payment of tax whilst you go through the upper tribunal. So we now move on to the upper tribunal hearings, and these are, I think, quite a streamlined affair. You're going to have two judges who you make submissions to, and they will have your skeleton argument that you'll write, and they'll have your bundles. The bundles will essentially be the evidence below in the first tier tribunal, the first tier's decision and any other procedural documents that have arisen since then. There won't be new evidence in that bundle unless there are very exceptional circumstances, because new evidence isn't allowed. The rule on that is that if the new evidence had it been before the first tier, would have affected the conduct of proceedings, then you can't have it in the upper tier. And that will almost always be the case. The rule's quite tight on getting in new evidence. You can put new grounds before the upper tribunal, again, so long as they're sort of legal grounds that wouldn't have affected the evidence before the first tier tribunal, because the upper tribunal starting point is the facts as found by the first tier stand. And it will be looking at whether, based on those facts, the first tier made an error of law. And so often, between getting permission and the hearing, all there is to do is build the bundles and write the skeleton and submit those according to the directions, and then you're into the hearing. And as I say, these often quite a streamlined affair. You've got two judges, normally an upper tribunal judge and a high court judge, and they will have read the papers and they will understand the issues, and they will really want to just delve deep into the legal questions before then. There's often they'll skip any preamble, that you won't need to go over the background facts. That can sometimes be a bit of a trap. You don't want to sort of assume that their reading of the case and the facts is the same as yours. So sometimes there can be a need to say, oh, I know you understand this, but I want to set out what I consider the important points and why I consider them to be important before getting to my legal submissions. But that so much can often be taken as read that really often the whole hearing can be a often quite freewheeling discussion, slash argument with the court about the legal questions you're trying to put. So from a law's perspective, quite a nice type of hearing, I think. But there we go. That after the hearing, you'll get your decision. Obviously, that can take between a couple of weeks if they basically know the answer going into, to 6 months, occasionally longer. Much very similar, I think, timings there to the first tier. Quite a lot of room for variation. If you win, great. If you don't, you have to consider whether you want to appeal again to the Court of Appeal. And this is, at first instance, again, quite a straightforward procedure. All you have to do is write to the upper tribunal and ask them for permission to appeal, and set out your grounds. And I think it's probably very unlikely, in most cases, for them to say yes on this. You'll be appealing on fundamentally the same questions of law that you put to them already, and they've considered those questions of law and decided against you. So they're not about to turn around and say, actually, we think your case is arguable, because they've just explained why you're wrong. So unlikely perhaps to get permission from the upper tribunal. You've got 1 month, by the way, to put in that application, which is again just by email to the tribunal. But if they say no, you can go and ask the Court of Appeal for permission to bring an appeal to them. And this is the stage where we leave the jurisdiction of the tribunal and enter the high courts and the CPR. So no longer are things so straightforward. And I think it's important to remember too, obviously, when you're drafting your grounds to the upper tribunal for permission to appeal, they've just written the judgment. They understand the issues and the grounds, and you can be fairly succinct. We now have to explain to the Court of Appeal what our appeal is all about and why they should take it, and they will need explaining from the ground up. So there are, as I say, we're under the CPR, and there are quite complicated rules in CPR 52 and the accompanying practice directions about what an application for permission to appeal to Court of Appeal must contain. There's a core bundle with a specified index. There's commentary on what you can put in a supplementary bundle. There's you have to write an entire skeleton, a set of grounds of appeal. That might be sort of what you've done already for the upper tier, but then also an actual skeleton argument setting out in detail your legal case. And when producing all that, as I say, it's important to understand that you need to start from the basics. That might be a lot of explaining of the law, etc., etc., because these aren't going to necessarily be tax judges looking at your application for permission. Although actually in reality probably these days you are going to be referred to either Lewison or Falcott, hopefully, who both really know their stuff on tax. But but anyway, you do have to be quite thorough. It is quite a time-consuming process with a lot of potential for getting things wrong. And there's standard directions for what happens after that point as well. If you get to the Court of Appeal, again, once you get into the court, the experience is actually rather like the upper tribunal. You're going to have, in this case, 3 judges, 3 Lord Justices of Appeal, one of whom will probably be the lead judge, and they will be the one really up on top of the issues, and they will be interested in burrowing deep into what your question of law is, and why you say you make have identified an error. And there's not a lot of accompanying sort of room for being expositions about what's going on by the time you get to the hearing. I'm going to stop there in terms of the journey, because I could repeat myself really with what happens onwards up to the Supreme Court. But I think if you're going up to the Supreme Court, you're going to have proper advice by then. And really the considerations are not that dissimilar anyway. So I will finish with a final point that I think is really important about cost risk, which is to remember that at the beginning of an appeal to the first-tier tribunal, costs are controlled. There's no cost shifting, which means that you pay your costs whether you win or lose, and HMRC pay their costs whether they win or lose, unless you're put on the complex track, but that's relatively rare and optional. So you can control your cost risk in the first-tier tribunal, and you might find as a client says, well, if this is what it's going to cost to instruct counsel, and my solicitor maybe, and so I'll pay that money, roll the dice. I've been advised my chances are good enough to risk that money. I roll dice and go through the process, and hopefully I win. And if I lose, well, I've lost that money, but there we go. If I win big because I had to pay the tax. But the nature of appeals means that that's not always right, because if you win, and your win is dependent on a point of law, on the tribunal accepting your interpretation of the legislation, the revenue might, and if it's at all important, will appeal to the upper tribunal. And they almost always get permission from the upper tribunal to bring an appeal on a point of law. And once you enter the upper tribunal's jurisdiction, you don't get the cost protection below. So if you win, yes, your costs are paid by the revenue, but if you lose, you pay not only your own costs, but theirs as well. And that's the same up into the Court of Appeal if the point is taken further. And then what this means is that if you, in terms of costs, a win in the first tier might be a pyrrhic victory, because you'll think, well, I've got my win, brilliant, and then the revenue appeal, and you're forced to spend a lot more money defending that win at the upper tier. And you have not at risk at that level, not only your costs, but the revenues. So it's really important, and again, that's doubled again if you go further up into the Court of Appeal. And revenue costs here are going to be in the region of 20 to 40,000 for a sort of fairly simple matter at each stage. It's usually litigation with multiple use cases that it could go much higher than that, but that's a sort of standard level. And so it's important to remember when advising your client about cost risks in a tax appeal, you've got to factor in what are the chances that if we win, will the revenue will appeal, and therefore how much costs might be at risk in the whole matter, because a win is not always straightforward. A win if you have to go on appeal and fight it all again. So with that, I'm going to say thank you for listening. I hope you enjoyed this episode, and I'll see you at the next TaxSnax.